At 2:47 a.m., Donald Trump posted something that didn't just anger our allies, it fractured the entire Western financial architecture. We're talking about a $27 trillion institutional alliance that has anchored global stability since Bretton Woods. And here's what nobody is reporting. This wasn't a tantrum. This was a calculated legal and economic offensive that prosecutors need to understand as witness intimidation on a geopolitical scale. What happened in the next 72 hours should terrify anyone who understands how power actually works. Let me walk you through what actually occurred, because the public narrative and the prosecutorial reality are universes apart. On January 23rd at 2:47 a.m. Eastern Time, Trump posted on Truth Social demanding that NATO allies pay their debts or face consequences. America will decide unilaterally. Standard Trump bluster, right? That's what most analysts said. They're wrong. Because within 6 hours, 3 things happened that prosecutors would recognize immediately as coordinated action. First, the European Central Bank's Emergency Committee held an unscheduled session. That doesn't happen for tweets. Second, Lloyd's of London suspended new sovereign debt insurance policies for 12 European nations. That's a $4.2 trillion market that just froze. Third, the German Constitutional Court fast-tracked a ruling on their military spending framework. A case that had been dormant for 8 months suddenly got oral arguments scheduled for February 3rd. You don't get that kind of institutional velocity from a social media post unless something else is moving behind the scenes. Now, here's where this gets prosecutorial. Trump is currently facing multiple federal investigations. The January 6th case might be stalled, but the documents case, the obstruction inquiries, the financial fraud investigations in New York, those are grinding forward. And every single one of them has one thing in common. They require international cooperation. Deutsche Bank records, Scottish property valuations, Middle Eastern financial flows. The DOJ doesn't just request that information. They depend on mutual legal assistance treaties, on NATO-level intelligence sharing, on the exact institutional framework Trump just threatened. Think about this for a second. A defendant in multiple federal investigations just declared economic war on the institutions that hold evidence against him. That's not politics. That's obstruction with a $27 trillion blast radius. From a prosecutor's perspective, you're watching a target try to burn down the courthouse by threatening the fire department, and the public is treating it like campaign rhetoric. But here's what they're not telling you. NATO allies have already started responding, and not the way you think. Let me explain what's really happening, because this is where prosecutorial strategy and geopolitical leverage collide. On January 25th, just 48 hours after Trump's post, the Netherlands Ministry of Justice did something extraordinary. They announced a comprehensive review of all pending U.S. legal assistance requests. That's Dutch diplomatic language for, we're reconsidering cooperation. The Netherlands isn't just another ally. They house the International Criminal Court. They process thousands of U.S. subpoenas annually. They're a cornerstone of transatlantic legal infrastructure. When they pump the brakes, that's a 5-alarm fire for federal prosecutors. Then France's finance minister gave an interview to Le Monde that every DOJ attorney should have memorized by now. He said, and I'm translating directly, France will continue to honor treaties with partners who honor their commitments to us. Read that again. That's not a policy statement. That's a conditional clause in what amounts to a mutual legal assistance treaty renegotiation. They're saying, you want our cooperation? Stop threatening our security. And here's the part that should make prosecutors lose sleep. Germany's Federal Intelligence Service leaked. And yes, it was a deliberate leak that they're reevaluating intelligence sharing protocols with nations that demonstrate unreliable alliance commitments. That's targeting data. That's financial intelligence. That's the evidentiary backbone of transnational fraud cases. Now, why does this matter legally? Because Trump isn't just a political figure anymore. He's a defendant, and defendants don't get to dismantle the evidence-gathering apparatus while they're under investigation. If you or I were facing federal charges and we threatened the institutions holding evidence against us, prosecutors would file an emergency motion so fast your head would spin. they'd call it witness tampering, obstruction of justice, abuse of process. But because Trump is doing it through foreign policy and a social media platform, everyone's treating it like political theater. Here's what they're not telling you. The DOJ is watching this in real time, and they're running out of legal options to stop it. Let me give you the prosecutorial framework for understanding what's actually at stake. In 2016, the DOJ prosecuted a Ukrainian oligarch named Dmytro Firtash. The case required evidence from Austria, Cyprus, and the UK. It took 4 years to assemble that evidence, not because it was complicated, but because international legal assistance moves at the speed of diplomacy. When one country delays by even 6 months, cases collapse, statutes of limitation expire, witnesses disappear, financial trails go cold. Now apply that to Trump. The Manhattan DA's case against the Trump Organization required records from Deutsche Bank's Frankfurt headquarters. That request went through German federal prosecutors under a treaty signed in 1986. If Germany decides that treaty is negotiable, if they start slow-walking requests because the U.S. is threatening their defense infrastructure, that case weakens instantly. The same logic applies to Scotland, where Trump's golf courses are under financial scrutiny. The same applies to Panama, to Dubai, to every jurisdiction where Trump-linked entities operated. You're looking at a prosecutorial nightmare, a defendant who can weaponize foreign policy to obstruct his own investigations. And here's the precedent that should concern everyone. In 2019, Recep Erdogan of Turkey was facing U.S. sanctions over his military actions in Syria. What did he do? He threatened to close Incirlik Air Base, a NATO facility critical to U.S. operations in the Middle East. The sanctions got watered down within weeks. That's leverage. That's how powerful defendants negotiate when prosecutors can't indict them through normal channels. Trump just learned that playbook, and he's applying it with precision. Now, pay attention to this next part, because it's where the constitutional crisis actually begins. The DOJ operates under the principle that no one is above the law. That's not a slogan. It's the institutional foundation of American justice. But what happens when a defendant has the power to cripple the institutions that enforce that principle? What happens when the target of an investigation can threaten the evidence-gathering apparatus itself? The DOJ has never had to answer that question at this scale. They're answering it now. And from a prosecutor's perspective, the answer isn't reassuring. Because the truth is, the DOJ's power is entirely dependent on institutional cooperation, domestically and internationally. Strip that away, and you're not just weakening one case, you're dismantling the rule of law itself. Let's talk about what this means, not politically, but legally and institutionally. First, understand that Trump's 2 a.m. post wasn't just reckless, it was strategic. He's creating a legal environment where prosecutors have to choose pursue accountability or preserve international alliances. That's a false choice, but it's an effective one, because the moment the DOJ hesitates, the moment they factor in diplomatic blowback before filing charges, they've already lost. Prosecutorial independence dies the second foreign policy considerations enter the charging calculus. And Trump knows that. He's not trying to win in court. He's trying to make the courtroom irrelevant. Now, here's the second consequence, and this one is generational. If Trump successfully uses foreign policy threats to obstruct federal investigations, he's established a blueprint. Every future defendant with enough power will point to this moment and say, if Trump could do it, why can't I? You're looking at the erosion of accountability for an entire class of political and financial elites. That's not hyperbole. That's precedent. And precedent is everything in law. Third, and this is what keeps me up at night, you're watching the judiciary become irrelevant in real time. Federal judges can issue subpoenas. They can compel testimony. They can sanction obstruction, but they can't enforce international treaties. They can't compel foreign governments to cooperate. If the evidence is overseas and the defendant controls the diplomatic levers, what exactly is a judge supposed to do? We're approaching a scenario where the rule of law depends entirely on whether foreign allies choose to honor it. That's not a legal system. That's a diplomatic favor, and diplomatic favors can be withdrawn. Here's what they're not telling you. This moment is bigger than Trump. It's bigger than NATO. It's bigger than any single case. This is about whether the American legal system can hold powerful people accountable when those people have the tools to dismantle accountability itself. And right now the answer is unclear. So where does this leave us? The DOJ is in an impossible position. NATO allies are making calculations that have nothing to do with justice. And Trump is exploiting the gap between law and power with surgical precision. From a prosecutor's perspective, this is the kind of case that defines whether institutions survive or collapse. Because if accountability depends on the goodwill of foreign governments, it's not accountability, it's negotiation. And you can't negotiate the rule of law. You either enforce it or you surrender it. Right now, we're watching that choice play out in real time, not in a courtroom, but in the 72 hours after a 2 a.m. social media post. Let that sink in. Stay informed. The next move will tell us everything.